Good morning, everyone, and thank you for attending today's webinar. The PIA Law is very proud to present the Practical Strategies webinar on the top 20 legal questions for 2020. This is our 15th webinar, and we're very proud to have over 200 people watching live today. Given COVID and everything that's happening in the world today, we purposely planned a much smaller panel than normal, so that's why we only have Troy here and Robert here. And we're also purposely separated farther apart. I'm not sure if you can tell that live, but in the office, that's how we are trying to handle this today. Before we begin, I just wanted to talk about a couple housekeeping issues. If you have any questions during the webcast, you can submit your question through question boxes below the video console. This includes any technical issues you might be having, and we're going to do our best to answer all of the questions during the webcast. So you can submit a question, I'll get it here on the iPad, and we'll try to get to your questions throughout the course of today. If a fuller answer is needed, or if we don't happen to get to your questions and we run out of time, we'll try to answer all your questions at a later date and send you a quick email on the topic you'd requested us to speak about. You can also see this through the PIA website. An on-demand recorded version of our webcast will be available approximately one day after our webcast and can be accessed on the PIA website. So briefly, I just wanted to introduce our panelists. To my right is Troy Lehman. He's a partner at Oatley Vigmond, and to my left is Robert Ben, and he's a partner at Thomson Rogers. And I'm Lindsay, and I work here at McLeish, Orlando. So I'm going to just get us started here, and what we'll do is through the course of the day, each of us will try to answer different questions that people have submitted to help us understand the top 20 questions. So one of the big things I think people are wondering specifically now is what's going on in the industry. Is business as normal for both lawyers, insurance companies, insurance lawyers? In my experience, I've found myself to be quite busy right now, so people are becoming used to working from home, and maybe a lot of people were already in that boat. But Troy, what are you thinking? What are you seeing in your practice?
Yeah, well, before I get to that, thanks to the people who submitted questions in advance. It was nice to get them in advance, so we get to do a little bit of prep before this starts. In terms of my practice right now, it's very busy. We were all very worried when this started about what would happen and whether we'd be able to work, whether we'd be able to service clients given what's going on in the world. But fortunately, we've been able to do that. We're entirely paperless, so transitioning to a large chunk of the staff working from home was pretty seamless. And people are working in the field. Insurers seem to be responsive, which is a good thing. We're able to get in touch with adjusters and defense lawyers. So it's been okay.
Robert, are you experiencing the same things?
Pretty much the same. I mean, we were deemed an essential service when the COVID crisis hit, and we took that to mean that we wanted to keep providing our clients all the help they needed and wanted to do that as seamlessly as possible. So obviously there was an initial period of a little bit of shock and what are we going to do and how are we going to shift. But much like Troy said, I think we've done a great job in making sure that we are still advancing our clients' files, keeping in touch with insurance adjusters, keeping in touch with defense counsel. So in a lot of ways, it's been not so much business as usual, but things are continuing to move forward without any huge interruption.
Yeah, what I've noticed, there's been a couple great decisions in court about using devices like Zoom so that matters continue to move forward in the right circumstances. So that's been helpful too. If we're ever experiencing difficulties with maybe some defense counsel that don't want to participate that way, there are a couple great decisions that have been helpful to us. And personally, I think it's going to create more efficiencies for us going forward and us to be better able to service our clients. So I think we're doing well as best we can. In terms of timelines and the statutory accident benefits, have you guys seen any issues and have those timelines changed at all in your experience?
I'll you start with that.
Sure. In terms of timelines, I mean, I think we all know that the government in March passed an order in council that suspended the running of limitation periods and the running of other timelines in various regulations. That doesn't necessarily have a direct impact on accident benefits claims, for example, except that it allows people who needed the time to put together a claim before the tribunal that additional period of time. For the most part, I found that my clients' accident benefits claims have been moving forward pretty much as usual. There's obviously an issue with conducting insurer examinations and the ability for insurers to do that in person, and there have been some delays or postponements in that regard. There's obviously been postponements of live hearings before the tribunal for accident benefits disputes, but telephone conferences, case conferences with the tribunal continue to go ahead in my practice. So, you know, we're not back to normal yet, but things have not completely stalled or stopped.
Yeah, I just got an email from the LAT yesterday. I had a hearing in July, and they said if we want to do it through teleconference or something like that, we can. So we do have the option, and in some cases that might make sense. Sometimes we want to have live hearings for obvious reasons. I don't know if Troy, you have anything to add to that one.
Yeah. On the limitation periods issue, the limitation periods have been tolled under an order of the government, but we're still able to file applications with the License Appeal Tribunal. So there's no reason to delay anything in terms of filings. Same with the court and tort. While the limitation periods are suspended, you can still file statements of claims, and we are, and you should, because otherwise there's going to be a delay in those claims. The timelines in the SABs for when insurers have to do things and when insureds have to do things aren't limitation periods. So that order doesn't apply to them, but there's no reason for those timelines not to continue to apply, and they do. So if there's a timeline in the SABs for an insurer to take a step, they're required to comply with that timeline. And those claims still move along consistent with the timelines. Where we're running into concerns, it relates in a big way to the insurer's examinations, which is one of the questions that was submitted that we're going to talk more about, I think. That's an issue. In terms of the LAT hearings, they've been canceled, the in-person ones, until September. So I had a case conference with the LAT not long ago where we were supposed to be starting a hearing in June next month. And that's not happening because it's an in-person CAT hearing. It's not the kind of hearing that you can do easily by phone or by video conference. So the decision was made, it has to be done in person. But they're giving the option to people to do hearings in writing or by telephone or by video conferencing. And Lindsay, you mentioned the decision by the judges, decisions by the judges about get with the technology. There's a great decision by a judge called Justice Myers. If you Google it, you'll find it, where he says, look, it's 2020 and we don't work by quill and ink anymore. We're going to do this mini trial. It was a trial by video conference, and the defense didn't want to do it, but they were forced into it.
Yeah, and I think like Troy was saying, some of this is making our practices more efficient. So both everyone's mentioning like filing claims, like that used to be a process of get a process server, go to the court. Now we can do this all online, and we're also able to commission through video conference. So there's some definite efficiencies that I hope stay, and I think will stay as a result of this. So that's that question. This one is sad for our most impaired clients. And what's your experience with your clients not having rehabilitation because of COVID, and how is that impacting them? And does it impact your case at all?
Sure. It's difficult. Obviously, there are a lot of our clients who need ongoing in-person treatment that requires close physical contact in a lot of cases. It's not always the case. Someone may need psychological counseling or therapy where the psychologist or the therapist and the client agree that they can continue to go forward and do it virtually or remotely. But there's a whole bunch of services that can't be done that way, and clients are obviously suffering because of it. From a lawyer's perspective, the one thing that I would urge people to do is document any sort of regression that a client has or may have because of a prolonged period of not being able to get in-person treatment. That's very important, because the thing I worry about as a lawyer, I don't know about Troy, I'm sure you do as well, is that 6 months from now, insurers or their lawyers may come and make the argument that, well, they didn't need or didn't have this service, didn't get this service during the COVID lockdown, and they don't seem to have suffered a lot. Do they really need it? And we're not going to continue to approve it or fund it. So I think it's very important where a person is having setbacks or regression because of lack of active treatment or therapy, that be documented.
Absolutely. And I feel for the clients who can't get the treatment that they need. And we're all talking to them about it. And people are really missing the therapies that they can't get, physiotherapy and massage, for example. People have told me, their pain complaints are so elevated because they can't get those treatments that they need in person, which is a huge problem for people's recoveries. But picking up on what Robert said, it's also a huge concern for us as their lawyers in terms of the claim for care going forward. And COVID's not the only thing that has interrupted treatment for us in the past. People run out of their non-CAT money, and they can't get all the treatment they need. Or there's other reasons why they're not getting the treatment they need. And insurers will take advantage of that. When we're at a mediation or a pretrial or a trial, they're saying, look, if you haven't had treatment, you don't need it. And there's not a need for treatment. This person has done well without the treatment. And why should we pay for it in the future? And the way to get around that is for the people who are able to stay involved, the case manager, for example, or the occupational therapist, or the psychologist, anyone who's able to stay involved and keep in touch to document what's going on, why this lack of treatment is causing the person to deteriorate. In your notes, and I can tell you, 6 months from now, a year from now, year and a half from now, when we're sitting down at mediations and pre-trials to settle these cases where people who have lived through this, we're going to be taking your notes for the healthcare peoples on this call and excerpting them into our mediation briefs where they're helpful, where they say, this person is really struggling because they can't get physiotherapy or massage. And it doesn't have to be the physiotherapist or massage therapist that's saying that, but it's very, very important. I can't emphasize it enough how important it is to document people's declines because of a lack of treatment in this environment.
Yeah. We kind of touched upon this question a bit earlier, just when we were talking about what are the deadlines and how is this changing in the SABs. What are you guys seeing with respect to like the IEs that we were talking about earlier and what's happening on that front?
Yeah, I can start, and then
Sure.
you can jump in, Robert and Lindsay. That's where the big challenge is that I see. There are some assessments that can be done by video conferencing or in writing, and those can move forward. But there's some that have been delayed that have to be in person, and they can't proceed. And we're seeing things scheduled and postponed, and treatment denials. In the meantime, where an insurance company has sent somebody for an IE, it can't happen, and then there's a question about whether the treatment is going to get funded in the meantime. And there are very good arguments that it should if the IE can't proceed because of COVID. That's the struggle that we're dealing with.
I don't think I have anything to add on that one, but again, just document what happens in the course of these denials. It's hugely helpful for your clients, and it makes our life a lot easier when we're trying to present a case. We touched upon this briefly too. So what's happening with our mediations and our hearing during the COVID time? I can start with this. I've been very lucky that all of the defense lawyers I've been working with have been open to Zoom, no matter they're tech savvy or not. Everyone seems very willing to learn right now, and I'm finding them actually more efficient. So I had 2 last week, 2 the week before, and they all were quite successful. So my mediations have been proceeding forward, and my understanding from lawyers in my office is that they've actually got their pretrial conferences to proceed too, which is a huge step in our practice, because if you don't have a pretrial coming up, then maybe your mediation might be less successful. So we were very enthused that some of these are proceeding. Are you guys having the same experiences?
Yes, I haven't had any cancellations by defense counsel or insurers when it comes to mediations. I think everyone is still committed to moving cases forward, and I think everyone feels comfortable with doing mediations virtually or remotely. And like you, Lindsay, I don't really see a huge difference. Maybe some mediators won't like me saying this, but I think the future might be that a lot of these mediations are going to continue to be done virtually or remotely even after COVID subsides. You know, your client, for example, my client, for example, can be in the comfort of their own home. They don't have to feel necessarily that anxiety of coming downtown to a, 36th floor office tower, a strange environment. They can be there with support people. They can take a break from, what might be a 6, 7, 8 hour mediation and go have, a lunch in the comfort of their own kitchen. They have the comfort of their family there to support them. Because in mediations, there is a lot of downtime or dead time while, the lawyers might be talking to the mediator about something, for example. So I think, there's a silver lining to this where mediations have become more efficient, maybe more comfortable, and hopefully in the end more productive and favorable to our clients.
I agree.
I'll share my experience, but before I do, make sure we come back to the IEs and why insurers should be paying for treatment. That may be another question, but I want to make sure we talk about that at some point. But while we're on the topic of mediations by video conferencing, I'll share my experience, and it's been very similar. The technology is wonderful. We were using it to some degree before this happened. I've used it in trials and discoveries before. Where you've got clients far away. I've had video conferences of people in the Bahamas. Didn't get to go there, had to do it on video conference. That would have been nice. But we're learning a lot about how it works in the mediation context. And it's my practice when preparing for a mediation to get the key treatment people to do some short videos on the very important issues. Why there's a need for treatment, why there's a need for attendant care, or the return to work and why it was a struggle from an OT, for example. And I find that's so much more effective than me talking to an insurance company, because they tune lawyers out, but they don't tune the healthcare people out. And you can do that by Zoom. And I've had I think 4 mediations by Zoom and 1 by WebEx, and you can put up your screen. And you can play a video. You can put up a picture of the accident scene, and just like you would if you had it on an easel in a boardroom. So it works well. There are some downsides to it. It's not perfect, but it works well. You don't get that same connection that you do when you're across from somebody. And you got to look at your hair, which is getting more and more unruly as we go through this. I find looking at myself distracting on Zoom, but I can minimize myself. So it is working well, and it's also working for Rehab Team meetings. Yeah. I don't know whether you've been on Rehab Team meetings since this happened, but I was on one sitting in my basement. Some healthcare people from the Barrie area, and it's nice to get together with people, but it was a good way to do it while COVID is happening.
Yeah, and just, I don't want to drag out the question, but I think you also asked about hearings. So I haven't had a full-blown hearing during COVID, but I can tell you, and you may agree or disagree on this, I think there's a place for doing some hearings remotely and virtually, but there are some that I wouldn't feel comfortable doing it at all, depending on what the issue was, what the witnesses or who the witnesses were, how high the stakes were for the client. Sometimes there's no substitute for an in-person examination of a witness in front of the adjudicator. Sometimes there's no substitute for an in-person cross-examination of an adverse expert or witness. And the thing I worry about is doing one of those hearings where it really matters through video conferencing. And I think, there's a potential to lose something there. So we think very carefully about, what we're prepared to do virtually and what we're not prepared to do. Obviously, we try to do as much as we can so that we don't delay and postpone things, but there are limits to it.
Yeah, it's very tactics and strategies still do come into play. So I don't think any of us have kind of forgotten that part of it. And we are lucky enough that we are part of a very collegial bar. So whenever there's any kind of technical difficulties on these things, people are very apt to just kind of go offline, figure it out, and come back on. So I've been very fortunate for how this is all proceeding, and I think everyone here has too. Let's just jump back quickly to what Troy was mentioning earlier, and just about, do insurers have to pay for services pending these delayed IEs and CAT determinations? What are your thoughts on that?
Yeah, I'll give you my experience and then my thoughts on the law. And I asked our accident benefits specialists in the office for their experience on it too. And for the most part, insurance companies, in our experience at least, have been decent about this, funding treatment on a without prejudice basis if there's a delay for their IE. Not everybody. There's always variability amongst insurance companies and adjusters, but you don't hear plaintiffs' lawyers compliment insurance companies too often. But in this environment, they've done a lot right, and that's one of the things that is the right thing to do. Morally, it's the right thing to do as an insurer for someone who's paid benefit premiums for years. In terms of their legal obligation, some insurance companies will say, look, we have a right to a denial, we have a right to an IE before we fund treatment, and we're not going to fund it without the IE. And the response to that is, you're wrong. That you have a duty of good faith. It's one of the basic principles of insurance law. I teach insurance law at Queen's, and it's the first thing I teach the students. There's this duty of good faith that applies to all of these issues. And I think the duty of good faith goes a long way to saying in this environment you should fund treatment. And it's not an absolute right to do an IE, and when you read the SAVs, there's a reasonable and necessary test to it. And I think there's a good legal argument that in this environment, if it has to be delayed, the IE is not reasonable and necessary for the time being. None of this has been litigated in the LAT. That's going to come.
Yeah. I mean, I've just speaking of the positives, I've seen a lot of positives from adjusters. So I think it's great in terms of people really need to go to the gym. That's their therapy. I've seen exercise bikes be approved, things like that, so people can do that inside. I've seen where people may be really doing well with volunteering, whether that's at like a Habitat for Humanity, but they need someone there with them. Well, let's figure out a project for the backyard, and I've seen approvals for that. So I think it's not all bad, and Troy's just giving you some great tips if you are getting that response.
Yeah, it's never my first instinct to be adversarial with an insurance adjuster, especially in a situation like this. I think oftentimes if you pick up the phone and have a discussion and say, look, we're all dealing with COVID. You can't do your IE in the timeline you normally would like. Can we, have some reasonable accommodation here and maybe continue to pay for some treatment while this process unfolds, and you can make your decision later, your approval or denial. So I think when you talk to the adjusters and really work with them, they're willing to work with you as well.
It's such a good point. I don't think it's any of our styles to be unnecessarily adversarial with anybody. And communication with the adjusters through this is so important. And if you're on the phone talking to them and advocating, in a professional way, you'll get things done, and that's really been our experience. But it's about communication, and it's such an important comment to make.
Yeah. So kind of on this note, there's a question about insurers' attitude toward claims handling and then settlement during COVID. And we were actually all kind of talking about this before, that we've been very impressed with kind of a lot of insurers, I think, maybe have a bit more time. And we've had a couple cases definitely settling, and things are for sure moving. So on my end, I think that they are having a good attitude towards these things and are looking business as normal, and we are seeing some cash outs happening. I don't know if you guys are feeling the same way, but.
Yeah, go ahead.
Yeah, I mean, my experience during COVID has been that a lot of insurers who have cases or files that have been ongoing for a number of years, and everyone has them. It's been a great opportunity for them to take those files out of the cabinet and say, okay, we're not going to resolve this in court in 2020 or 2021, maybe not till 2023 because of the backlogs in the courts because of the lockdown. And I don't think it's in the insurance company's interest to keep files open for that long. And they've, I think, shown a willingness to open up their files, revisit them, and reach a reasonable resolution. So I've settled a number of files on that basis. Do I sometimes feel that some insurance companies have taken advantage of COVID and perhaps attempted to undervalue the settlement of a claim because they might think our clients are financially desperate because they're not able to go to work if they're not disabled from doing so? Sure, the skeptic in me suspects that in some cases, but by and large, I think most people are on the insurance side are continuing to deal with files on the merits and are still actively trying to settle it. They're not trying to intentionally delay anything or take advantage.
Yeah.
And that's been my experience, that insurance companies are settling files and they're dealing with claims. And defense lawyers have time to deal with claims, which is another thing. There aren't any trials happening right now, and there won't be for the next few months. I was supposed to be on trial right now in Peterborough. That's not happening. Lots of defense lawyers are in the same situation. And that's one of the things that can hold up the settlement, people being too busy. The defense lawyers have time to deal with cases. There are some insurers that may try to take advantage of financial desperation of people. That's a concern. It's our job as lawyers to make sure we're getting full value for cases, and may have people that are desperate to get their case settled, but you got to have a very hard discussion with them about not selling it for less than its full value. The big concern that I have, though, relating to settling cases relates to trial and the lat hearings too. There's nothing like the pressure of a looming trial date to get people serious. I can tell you, I had a Zoom mediation that didn't succeed, and it was a case where the lat hearing on the catastrophic issue was scheduled for July. And we'd scheduled this mediation for May. It happened earlier this month. And before the mediation happened, we got notice from the lat that the arbitration wasn't happening. It was going to be bumped. And we haven't rescheduled it. But all the pressure fell away. And the offers that we got weren't reflective of the insurance company's risk. And my suspicion in that case is that, there was no trial pressure on them, and there was no reason for them to get real, so to speak. So that's a concern.
Definitely.
Yeah.
Switching gears a little bit to more technical stuff that's happening here. What is everyone's take on the CERB and the CSB and the impact on like the IRB claims and loss of income claims?
Yeah, for this one I have to look at some notes. This is brand new, something we haven't dealt with before. So the CERB, as I flip to my note, is a benefit, as everybody on this call would know, to people that pays $2,000 a month. if they've lost their job or can't work because of COVID-19. And it's the Canada Emergency Response Benefit. It's paid if you stop working because of COVID-19, unless you quit voluntarily. And more than 7 million people have applied for it. So there are lots of our clients, lots of healthcare people's patients who have applied for this and are receiving it. There's also the Canada Emergency Student Benefit. Doesn't have an acronym that you can pronounce, the CESB, for students who can't work because of COVID-19. So the big question on people's minds in our industry is, how does that affect your tort claim? How does it affect your income replacement benefit? So on the tort claim, the measure of damages in a tort claim is the difference between what you would have earned for income versus what you're able to earn after the accident. If you can't work because of an injury and you're not working because of the injury, you're not going to be entitled to the CERB. So in those situations, there won't be a CERB benefit. But you could have a situation where somebody is working before their accident in a job, and then they have to leave that job, go to another, making less money or working part-time, and then they lose that job because of COVID-19, and then they're getting the CERB benefit. And then the question becomes, should the CERB benefit be deducted from their income loss? And the defense lawyer would say, look, we're only responsible for losses that we caused, losses because of the accident. And we're not responsible for any losses that would have been suffered in any event of the accident. So if you've got a client and their business closes, for reasons other than COVID-19, the tort defendant's going to say that would have happened anyways, and we're not responsible for the income loss. So it would depend on every case in terms of whether the person's financial position would be different. If they'd be working without COVID-19, making more money than they would have because of the injury than they are able to now, and they're getting the CERB, then the difference should be made up in tort. So every case is different. On the income replacement benefit analysis, I read 3 papers by 3 different accounting firms in the last couple of days because we knew this question was coming. And these are all accounting firms that do lots of work, and the answers were different. Some said the CERB would factor into the income replacement benefit, and others didn't. In terms of the income replacement benefit, I'm talking a lot here on this question. There's 2 questions, really. One is, would the CERB be factored into the income that a person has, that their benefit is based on? i.e. or EI income is. So determine entitlement, you look at the person's gross employment income. That's the test in the SABs, which is defined as salary, wages, and other remuneration from any employment and any benefits received by EI. So the question is whether the CERB fits into that language. Is the CERB salary, wages, and other remuneration from employment? That's a question that the accountants differ on. It isn't EI, but there's an argument that it's akin to EI and should be included in calculating the IRB entitlement. There's no decisions on that yet. And then the other side of the coin is if somebody is getting an IRB and then they get the CERB afterwards, does it get deducted? I think the answer to that is no, it shouldn't be deducted. The language allows insurers to deduct all other income replacement assistance and any gross employment income received by the employed person as a result of being employed. And I don't think the CERB fits into that. So if an insurance company is trying to deduct the CERB off of an income replacement benefit, my take is that they'd be wrong about that. Long answer, but
Yeah.
That's okay.
it's a complicated area of law.
And luckily, we have
Yeah.
accounting firms that help us out daily, so.
And there will be fights about this,
Yeah.
regardless of what Troy says.
Yeah.
The right answer is, I can guarantee you that there will be disputes about this from insurers and defendants in tort claims. But the one thing I worry about as a lawyer, especially in a tort claim, is I know that it's been reported a lot of people applied for CERB just, when it was announced because, they needed it. And the process is simply going online and basically, checking a box saying you meet the criteria, one of which is, are you unable to work because of COVID? And what I worry about is defense arguments to say, well, look, when you filled out this government form on the website, you understood that you had an obligation to be truthful. And, you checked off a box that said the reason you cannot work is because of COVID. That's the reason that you're not able to earn an income. And the inference there is that they don't have a disability that would otherwise prevent them from making an income. So I think in some cases, we might have to have conversations with our clients about, that and whether they were originally rightfully entitled to the CERB or not. And I know that the government has announced that, people who wrongfully applied for it can return it and they may claw it back later. So, but again, it's a case-by-case basis. It depends on the individual person's situation.
Yeah, that concern is a huge one. And if you've got a client who's considering whether or not to apply for this CERB, it's important that they speak to their lawyer about it and how it's going to impact my tort claim, how it's going to impact my income replacement benefit. Because when you read the eligibility requirements, you can't work because of COVID, and otherwise you would be able to, is the inference. And that's the real concern that we have as lawyers in terms of how it would impact the claims.
So a question came in, and I think it's kind of on point to this topic. It's just asking, what are your thoughts on clients that used to have attendant care benefits? They had a PSW coming in. They're not feeling comfortable with the PSW because of COVID, and now they want a family member to do this. What happens because the adjuster's going to say, well, there's no economic loss here because the family member was laid off because of COVID. Have you guys seen this happen at all, or?
I have not seen this particular situation happen. I have clients where either the PSW company, at least in the early stages, was not providing any in-home services. But since then has shifted to providing some virtual attendant care in terms of checking in, supervising, cueing and prompting, things like that. Family are always helping out, even when people do have a PSW. That's the reality of it. From an accident benefits perspective, I can see how that may be potentially problematic, where you're talking about the incurred expense. I'm not worried about it at all from a tort perspective. I think that, at law in tort, it doesn't have to be a professional service provider. It can be a family member, and the courts and the law recognizes a value of the service that family members provide in the nature of attendant care. But yeah, I mean, this is going to be something we're going to have to wrestle with on the accident benefits side. I don't know the answer.
Yeah, I think they'd still have to show incurred, unfortunately, the way I read the SABs as of today's date. But just flipping to tort, a lot of the times what we do when a family member's providing a lot of the care is we have them fill out kind of their own Form 1 to show us, like, when we go to discovery, when we go to mediation, it's not that there's not a PSW, it's that a husband, a wife, a brother, a sister is doing all of these services, and it kind of helps us out. But on the incurred piece, I don't know if you guys have any other thoughts, but I don't think there's a way around it if the person's being laid off.
Yeah, I guess the only way around it would be to make the usual arguments that we make in incurred. If somebody loses their job and provides attendant care, if they could have got another job but they haven't to provide attendant care, then you've got an argument. We've all had cases, I think, where a family member loses a job and provides care, and then we're arguing about whether the incurred expense is made, and the insurance company is saying, look, the job loss had nothing to do with providing attendant care. And we're saying, well, it did. And now he's providing attendant care, she's providing attendant care, and can't work. And if you've got job offers, then you can prove an economic loss. Every case is different, but the question's a good one because there are lots of people out there who aren't working who are now providing attendant care. And under the good old system, they'd be compensated for that without worrying about incurred. Under the system we have now, we've got to make arguments about it. In some cases, there might be arguments where somebody's left work, could have had another job, but has decided to stay home and be an attendant care provider because a PSW can't come into the house.
Yeah.
You know, if a PSW can't come to the house and somebody leaves a job and suffers an income loss to provide attendant care, then absolutely they get compensated for it up to the level of their income loss. Yeah. And that's a real problem. PSWs not being able to come into people's houses right now.
Yeah. So kind of going back to the technical side of this morning, Robert, I just was hoping you could talk a bit about this Gerard case in Cunningham, and
yes,
it kind of relates
that's
to this a little bit.
Case.
Yeah.
I mean, it's an interesting case if you want to look it up, and there's been a lot of written commentary about it. The case name is Gerald, G-I-R-A-O. I won't go into a lot of detail except that it involved a self-represented plaintiff injury victim who I think, and the Court of Appeal recognized, was unfairly treated at trial by the defense. And really the only reason I wanted to talk about this case is there was an interesting comment by the Court of Appeal about a line of cross-examination that the defense undertook concerning this injured woman's failure to mitigate or minimize her income loss, and whether she was in fact even motivated to try and get back to work because she was receiving collateral benefits like CPP disability, income replacement, that type of thing. You know, and the bottom line is I won't get into all the finer legal points, but I think the Court of Appeal suggested that, lawyers on the defense side have to be very careful cross-examining on these areas of lack of motivation to work or failure to mitigate damages like income loss, because the potential prejudicial effect is often outweighed by the probative value of that type of evidence. But the Court of Appeal did recognize that if something like that was properly pleaded in the statement of defense, then it was relevant, and that, within certain limits, the defense could cross-examine on that. So anyway, this long-winded description really gets to the point of, what does this matter for you if you happen to work in the healthcare industry working with injury victims. I think we have to be conscious of the fact that in the future, defense counsel are going to bring this up regularly. This person's not motivated to work because they're getting a lot of benefits. This person has not done anything to improve their situation, and therefore we're not responsible for their loss because it has nothing to do with their disability. I'm not a clinician, so I would turn to you as the experts and ask the question of, what motivation does a person have to game the system where they're only making 50 to 60% of what they would have otherwise been working if they weren't injured. I think we have to document that. It all comes back to what we said at the beginning. It's all about documenting and interviewing clients and getting a real deep understanding about, yes, they do want to go back to work. In fact, the cause of their anxiety and frustration and depression is in part related to their inability to earn an income and pay their mortgage, pay their rent, put food on the table for their kids. This is extremely stress-inducing for people. They would want nothing more in the world than to go back to work. But they can't for reasons A, B, C, D, and E, and they've tried, but they can't. So it really takes the wind out of the sails of the defense argument that, look, you're faking it. You could go back to work. You don't want to go back to work because you're getting all these benefits. No one, I believe this in my heart, none of my clients would ever want to be in receipt of benefits rather than working. They'd rather be working. So we just need to document that and be aware of that as a potential issue.
Yeah.
I agree. And here's the defense argument in a case that they advance it strenuously. You've got somebody who's working, making $40,000 a year, and maybe they've got a history of absences at work, and now they're getting income replacement benefits from different sources that add up to $35,000 a year. So they're making, just a few $1,000s a year less than they were. They might have an invisible injury, and one that the jury can't see. And these are jury cases where the real concern happens, like chronic pain or a mild traumatic brain injury. And the defense argument is, look, you're happy to stay at home. You're not motivated to return to work because you're making just about as much money as you're making. And maybe they've got evidence that this person is on the computer playing a lot of video games all day. And the argument is, look, you're happy just to sit at home playing video games rather than work. And that's the argument. And as lawyers, we have to inoculate against that argument. One of the biggest ways we can do it is with the assistance of the clinicians, the healthcare people, documenting the impairments, but also documenting what our client did to try to mitigate. We have this obligation, if you're in a lawsuit, to mitigate your damages, which means you have to try to improve your situation. So attempts at volunteering with an OT or a rehab support worker, where there's been all sorts of documented struggles, that'll blow up that argument. And you can call the people from the volunteer place to say, here's the struggles this person had, and they were really trying. Or attempts to go back to work where there's struggles documented in the healthcare records. Someone who's committed to therapy. We want to be in a position to say, here's the evidence that shows our person was trying and doesn't want to live a life of disability. They're trying, but they're failing. It's all documented from the healthcare people. In that case, it's worth a read. It's an incredible set of facts. It's a woman who is an immigrant to Canada, and her English isn't very good. She's self-represented. She doesn't have a lawyer. The Court of Appeal was critical of the defense in terms of a number of things that they did in the course of the trial. It was not a fair trial that she got in front of the jury. She needed a lawyer to think these through and inoculate against these issues, because I think the Court of Appeal thought she had a legitimate case and just wasn't treated very fairly by the system.
Again, staying kind of more on the technical sides of things, when you're looking at CAT applications through brain impairment, what's your thought on brain imaging to support the GOSI CAT applications?
Sure. You want to start with that one, Robert?
I mean, I don't want to get too technical. I'll probably put my foot in my mouth because it gets very technical.
That's why I had Robert.
But, what we're trying to do, obviously, as you're probably aware, in order to meet the definition of catastrophic impairment through the GOSI criteria, you need to show some positive imaging, medically recognized imaging, I think is the exact term, that shows intracranial brain pathology. So you need a picture to show that there is some damage or injury to the brain. And we all know that, CT scans are not fine enough to pick that up often, except in the most serious brain injuries. The same with MRIs. So, what we look for is, how can we establish this in other ways? And I know that there have been some attempts to use and explore other imaging like SPECT, QEEG, other sort of technologies that can confirm that there is some pathology or injury in the brain. So a lot of this stuff hasn't fully been tested in the courts or before tribunals, but we are trying to push that. We've got a number of doctors who are using it and willing to endorse it. There will certainly be fights around that. But it's a challenge, especially in cases of mild to moderate brain injury where neuropsychological testing, for example, confirms that there are brain injury related deficits, but we don't have that picture. So, I guess the good news is that, medical technology advances so rapidly, what we have today, we didn't have 20 years ago. So, I imagine that 10 years from now, the ability to detect brain injuries, even if they're subtle, will be vastly improved. So we're optimistic.
Yeah.
I can talk about my experience with SPECT.
Sure,
Because
yeah.
I do have some experience here. Had a trial where I called Dr. Xiao, who's a doctor at South Lake Hospital, neuroradiologist who does MRI and SPECT interpretations. Very, very good doctor and a good witness. We have relied on a SPECT scan to meet that test in the SABs, in the GOSI part of the CAT definition. His evidence is very persuasive that it's medically accepted and it shows an intracranial brain dysfunction, which is what you need on the test. But what it doesn't show is whether it's from a particular incident. I mean, that's the challenge. Because you can have a positive SPECT scan, but it doesn't mean it's caused by that concussion or that brain injury if the person's had more than one. And that's where the challenge lies. If you got a CT scan right after an accident showing a bleed, that's easy.
Right.
But the SPECT scan is more challenging. And the way to deal with that is to make sure there's evidence that this person has only had one very significant trauma that would have led to that finding on the SPECT scan. We've also started to use functional MRI, which will pick up things that normal MRIs don't and CT scans don't, and have had some success with that as well.
But on that, back to the point of Dr. Xiao and the SPECT scan, I know that in cases where the question is this from a accident-related brain injury or is it pre-existing? In one case that comes to mind, we had some corroborating evidence that actually the neuroradiologist asked us to look for, and it was very helpful where at the time of the accident, there were photographs and documentation in the hospital record about bruising and lacerations on an area of the head that corresponded with or matched the SPECT imaging. So it was very persuasive in that case. So a lot of times you're going to have to dig, and you're going to have to face arguments from the defense that this is not clinically used, it's a research-based imaging. But I think those things are going to evolve and they're going to change. So we're always pushing to the limits on that. And
Are you guys still going to the SPECT scan? Because there has been some cases back and forth on it. Or is it something you guys still use when you're trying to get your clients CAT?
Yeah, I use it regularly in so-called mild traumatic brain injury cases for tort purposes and for the GOSI purpose. Doctors have different views about it.
Yeah.
There's a medical debate about it, but I've found it to be helpful. It's certainly helpful with a jury in a tort case because you can show a picture. Here's what a normal SPECT scan looks like, and here's what this person's SPECT scan looks like, and that's persuasive for a jury in a tort case. In this accident benefit situation, because of the language of the SABs, there's going to be a debate about whether it's medically accepted technology. You just have to make sure you have the right evidence about that, but it's an issue that you got to be live to.
Okay. This one's similar. I think the question is really phrased towards how to get a client CAT based on the mental and behavioral test. And obviously we all know that it changed. It's much harder now. You need the 4 instead of the 1 or 1 class 5. How have you guys been seeing these results come back, or are you providing more evidence to help get your clients CAT based off mental and behavioral?
Yeah, that was the one part of the SABs definition I think insurers were probably happiest that got changed. Maybe not. Maybe it was the GCS.
Yeah.
But there's a big difference, obviously, between 1 marked impairment and 3. Just to give you the big picture for the people that don't read the SABs all the time, part of the CAT definition is whether you have a mental or behavioral impairment that gets to a certain degree marked impairment in one of 4 areas of function. Activities of daily living, social function, concentration, persistence, and pace, and adaptation to a work-like environment. It used to be we just needed to prove 1 marked impairment. There's a whole bunch of interesting law that led to that. That's all out of date now. Now you have to prove 3. That's a pretty high threshold. and it's changed in a big way. Still see psychiatry reports that get there if you've got the person with that level of impairment and the right evidence. That's what you're getting at. And it's so important to gather the evidence. OT evidence, for example, is so helpful in terms of what's this person's real impairment in terms of activities of daily living, concentration, persistence, and pace. Just sending someone to a psychiatrist alone, you're going to have an evidentiary problem, I think.
Yeah, you need that factual foundation for a psychiatrist. From an OT, for example, that contrasts the before level of function with the after level of function in each of those spheres. And, I agree with Troy. I think it's very difficult to meet in most cases. It might even be impossible in a vast majority of cases. But certainly the more factual evidence you have that shows actual functional impairments, it really makes it a lot easier to try. But it's difficult. It's a difficult test to meet.
Yeah,
absolutely.
And if you're an RSW or PSW, don't underestimate the value of your notes too, because a lot of the times with people with brain injuries, for instance, they might be able to go to the store, but they may only be leaving the house because you came. And they may be asking you, can I buy this? Can I buy that? Can I buy this? But if someone's just watching on camera, they're thinking, oh, they can pick food items out. So don't underestimate how important your notes are too. You're there most frequently, and oftentimes I'm quoting your briefs or your notes in my briefs most frequently. So I think those also help with the mental behavioral checklist too.
Examples, right? And I think just a quick point, because I know we're running out of time, but with children, I think you've got the ability to talk about developmental implications. So where someone may be functioning at a moderate to marked range of impairments, but they're not, unequivocally markedly impaired, you might predict that, as they progress or mature into adulthood and different challenges arise, higher level abstract thinking is required, judgment, that developmentally they're going to, be markedly impaired very soon or shortly. So you might want to approach that as well.
Yeah. So this one's also sad. We've been talking about these changes to the CAT definition, and we're looking here at how do you manage 1 million of the combined med rehab and attendant care. And it's tough and it's really sad, especially if you have young kids that are catastrophically impaired. There's just simply not enough money. Or if you have someone that's 24-hour care in their 30s or 40s, there's just simply not enough money. So what are you guys doing in your practices when you're in these unfortunate situations?
It is such a shame that change was made for the most seriously injured people, and especially the young people who have a lifetime of needs, and now you've got $1 million for their med rehab and their attendant care combined. It's a team effort, I think, in terms of managing it. You have to make sure you're getting the treatment that's needed, but there's a need for prudence in terms of not wasting any of that money because it's so very precious. In our office, we want to make sure the insurance company is giving the breakdowns of benefits as they are required to do, which they don't do automatically, to make sure that everyone has a handle as time runs and how much money is being used up. So sometimes it all gets used up very quickly and there's nothing you can do about it. I mean, I've got such a sad case of a young girl who's close to the same age as my kids, and that always hits close to home, with a brain injury, who just needs so much care that the money is going to run out before she's 18. Fortunately, she's got a tort case and there's insurance limits beyond the norm, so don't have to worry quite as much. But imagine she's got no tort case. There's only $1 million. In that case, you have to be very careful, and you got to look at government programs to supplement the SABs.
I think.
Yeah, just quickly, my perspective on it is, and I say this to clients and rehab team members, I say, look, it doesn't matter what I say. It matters what the rehab team says or what the client says. And it goes back to documentation. If the team is making decisions with family input, I'm thinking of a catastrophically injured child, for example, that says, look, she needs SLP, PSW, RSW, OT, psych, once a week, but we can't afford to do that. So we're going to do it once every 2 weeks. Document that. Say, we are making a conscious decision here because there are limited funds that need to meet her lifelong needs or long-term needs. We can't provide the required level of service, so we're doing the minimum therapeutic level of service, but she definitely needs more. If there was more money, she could do it. So you've got to be able to document that you're rationing a limited fund of money, and that's driving clinical decisions.
Yeah, and you can see that a lot for housing stuff where let's come up with a solution that might not be the best solution, but we have to conserve funds or prosthetics, things like that. But yeah, it's an unfortunate situation to be in, and hopefully you've got a good tort claim because that can help too. This is kind of on the same point, but can you guys just briefly run over the test for future benefits or future damages?
Let's start with that.
So this is a conversation I routinely have with doctors and other clinicians, more often than not with doctors, because for some reason they need to be shaken from this scientific viewpoint that they have about prognosticating the future. So the law is there are different legal standards. To prove an injury, for example, all we need to do is show that on a balance of probabilities, this caused that. But when it comes to the future, the law recognizes that no one has a crystal ball. We don't know whether someone may need A, B, and C services, 20 years from now, or whether they will not be able to work 20 years from now. So there is a bit of speculation involved in it. And unfortunately, the person only has 1 day in court to prove and capture all their losses or compensation, even if they're 20 years down the line. So what I tell doctors and other clinicians is, look, I understand scientifically you don't know whether this person will continue to have problems or develop problems in the future, but the law is much more relaxed than that. All you have to answer is there a real and substantial risk, or is there a real and substantial possibility of this future loss or need arising? And the courts have said, substantial risk is something more than de minimis, more than a mere trifling possibility. So something that is on the order of 10%, 20% that a doctor might think is clinically insignificant is legally significant. And the jury will be able to make an award of compensation that reflects the risk of that future event happening. So I think it's important to make sure that you can distinguish between your clinical scientific standard of, prognosis, and understand the legal test.
Yeah. Doctors and healthcare people don't think like lawyers do, because some of us lawyers took history degrees before we went to law school, and we don't think like scientists. But the law is not scientific at all. That's the test, and it is a struggle for the medical mind to understand that. Even the balance of probability test, when you're talking about whether an injury is caused by something. It's a different test than the test for future damages. It's on a balance of probabilities, but doctors don't think that way either. And if you're dealing with some causation issue or a medical malpractice case, you need to spend some time educating them on what the legal test is. And it makes sense that it's a lower test for the future, because it's impossible to crystal ball what the future is going to be. And that's our challenge, the courtroom. And it's a challenge of future care planners to try to crystal ball things. And you got to understand the legal test to do it properly. At the same time, without overreaching, which I think is another question we're going to get, or we've got to talk about.
The next two questions, I'm going to combine two questions. I hope that's okay with everyone, but they're so intertwined. Just talking about exaggeration, overreaching, credibility with the court. The next question is about how do I write a defensible report? And those two are on the same lines. So, Robert, do you want to lead us off with that?
Well, yeah, this is another pet peeve of mine, because you know, at the end of the day, we have to advocate for our clients, and we prepare to do that in a courtroom setting, in front of a jury more often than not, and if not in front of a jury, then certainly in front of a judge. So everything we do in preparing the case is geared towards that possible way of resolving it. And we have to tell the client's story, we have to present the evidence. And, you know, a recent decision came out from the Superior Court, and forgive me, I don't remember the name, but there were a number of good quotes in there, and I'll just borrow directly from it, where the judge said, exaggeration is the enemy of credibility. And that's absolutely true. And I think the judge went on to say, look, you only get one chance at a first impression in front of the court. If you exaggerate anything, that's going to color anything else that the court hears from the lawyer or from the client or from any of the expert witnesses. So it's very important to be realistic, very important to be reasonable, very important to understand that if you're giving evidence in front of a jury, that these are everyday, ordinary people that are reasonable. They're going to bring their common sense to bear. You know, if you're putting something forward as a recommendation that is not realistic, that is not reasonable, that is not founded or based on the evidence, they're going to know, and they're going to be turned off by it, and it's really going to harm the rest of the case. So it's really important to be pragmatic, realistic, at the same time recognizing that there are future risks that need to be addressed, but it's got to be defensible.
Yeah, I mean, and it might be things that you don't think a lot of. They could be inexpensive items, but I had a trial once, and, you know, I'll never forget this, because they're going through our future care report, and the defense lawyer is just, you know, being dramatic, a good defense lawyer, and saying, a Swiffer. You're asking for a Swiffer? And you can see the jury saying, well, we all own a Swiffer. Like, why is this? And it's this very small thing. It doesn't cost a lot of money, but it gets a jury to thinking they're overreaching. They're asking for too much. So it could even be something small, and we'll do our best as lawyers to try to coach you through each case to help you make sure things that you think are appropriate are included, but we're not going that extra distance. And you'll have a better time on the stand for sure if that's the case.
Yeah. You got to remember, when you're writing a report or making a recommendation to a future care planner, which everybody does who does clinical work at some point, who your audience is. Ultimately, you know, there's two audiences. First, there's an insurance company, and then there's a jury or a judge. But most of these cases are jury cases. And I'll start with the jury in terms of their preconceptions. There's been lots of social science research about this, primarily in the States. But juries have a preconceived notion about people who are in these claims, and lawyers, which has crept into Canada, I think, probably because of the advertising that happens that you see, some of which is crass. And they're automatically distrustful of the lawyer and the litigant, any hired experts. And the way to get beyond that is to be credible at every stage and not to overreach, and to be conservative. You know, maybe there's a recommendation that you could have made, but you don't, and that can gain you credibility with a judge or a jury, if it's something like the Swiffer.
Yeah.
Or, you know, if I see a report that's got $400,000 of housekeeping assistance in it, I know that as soon as the insurance adjuster reads that, they're not going to read anything else, because they're going to think it's just over the top on that point, and it impacts the credibility of the rest of it. So it's you know, it's a balancing act like everything else. You want to make sure the needs are addressed, but that nothing's overreaching.
Yeah, and like you can play with like replacement periods and things like that to help you gain credibility, and then you can always say, well, typically it's this 5 years, but we've used 10 years, and these little things, are these hidden persuaders, actually can help win a jury over. So we'll, as lawyers, we'll try to help with that too. So I'm going to start kind of going to some of the questions that are coming in live now. So given the events surrounding the pandemic and the significantly reduced amount of motor vehicle accidents, how do you see the future of personal injury over the next few years? Okay, I can start. I can start. Yeah, I mean, obviously that's something that people are seeing. You're not seeing as many crashes, but we're still having cases come to our firm. I'm sure Troy and Robert in the same position. We're meeting clients through Zoom and obviously conforming with our social distancing requirements, but we're still having things coming in our doors from my experience.
Yeah, I mean, there's certainly less people on the roads, and that means less accidents, and that's a good thing for society.
Yeah.
It'll have a temporary impact on the volume of work in the business. There's no doubt about that. But at the same time, we are seeing new cases come in, and everybody had lots of fears and dreads and still have them. But what we're seeing right now is reassuring, I find, in terms of people being busy in the field. I think we're going to be really busy in the future because there's a backlog of trials and hearings, this will end and people will get back to doing things. It's temporary. It'll have an impact. And as an industry, we've been through this before through non-COVID related issues, where there's changes to the Insurance Act, and every one of those is intended to take away people's rights to some degree to bring claims. I shouldn't say everyone, but the vast majority. And there's lots of angst about that. But the people who do good high-level work have always stayed busy through all of that in the legal field and the healthcare field. And I'm a pretty optimistic guy naturally, but I remain optimistic about the future and in the field that we work in and that the healthcare people work in, that there's going to be lots of work, and pretty soon we'll all be complaining about how busy we are. we already are.
Yeah, I feel quite busy, and I know from the healthcare perspective, maybe at the beginning everyone was a bit confused, what can we do? But my office, and I'm sure your offices as well, have seen some great creative solutions from a whole number of different companies so that services can be provided even if they aren't like an essential PSW going in. There's lots of virtual things happening, even like Troy, you mentioned your virtual team meetings. Well, that's great, and so I think things will start to kind of flow again.
What I foresee as a big potential change in the future, in the after times, whatever you want to call them, is that, people have adapted to providing services virtually in different areas. And I think that may become increasingly the norm. And I think maybe some insurers may actually demand that that's going to be the norm. For example, a rehab team meeting, insurers might take the position, well, why do you all need to travel to the client's home to do this? Why can't you all do this by Zoom? Maybe that's the right answer. Maybe that is the reasonable solution because everyone is now familiar with that technology, has it available to them, and it's probably more efficient for everybody. But yeah, that's where I see some changes where, fixes or adaptations that we've employed during COVID may become the norm afterwards, remote working, less travel time to provide certain treatments or consultations, team meetings, that kind of thing.
And there's a concern about that. We were having a partners meeting, a discussion about whether this would be the new norm for mediations and pre-trials and even trials, doing it on video conferencing. That's a good thing, and efficiencies are good, but at the same time, there's a need for in-person events like trials and mediations. And on the healthcare side, there's absolutely a need for in-person meetings and treatment. There's a fear that insurance companies will say in the future, we're not going to pay for travel time or in-person costs where they could be done by video conferencing. And we'll have to push back against that, is my thought.
And I think last night there was a release from the court, some advisory committee about, modernizing the court system. And one of the things they were recommending is modifying the rules to make electronic hearings or procedures by default the rule, except if you could show cause that you needed an in-person appearance or a meeting. So I think in the treatment realm, that might be the same thing. If insurers start to say, look, by default, we expect you to do this remotely. If you can show cause why in this particular case, well, no, that doesn't work because the client needs us to be there for reasons A, B, and C, then that's what you'll have to do.
And you got to remember who we're dealing with in a lot of these cases, very vulnerable people who don't have the same comfort level with technology that we do. People with brain injuries, picking up cues and working on treatment goals. You can do what you can do over video conferencing, but it's not a substitute for in-person treatment and sessions, and documenting that and pushing back against insurers trying to save money by putting things online is going to be a challenge, I predict, going forward.
This one's a good one, and it's not around COVID, so that's great too. If an injured person sustained injuries in 2 motor vehicle accidents, with the second event worsening injuries and impairments from the first, how would impairments be divided among the 2 accidents, especially when looking at catastrophic status with regard to the second accident?
The case I was supposed to be on in June in the LAT was somewhat similar to that. Wasn't 2 accidents, so a workplace injury and then an accident. But it's really a causation question. You've got somebody injured in one incident, and their injuries get to a certain threshold that don't meet the catastrophic threshold, and then they're in another accident and their impairments elevate to the point where they now meet the test. And how does that work in law? The Licensed Appeal Tribunal and FISCO and the courts have all adopted a but-for test. You've got to prove that but for the accident, you wouldn't have the catastrophic impairment. In other words, you wouldn't have got to the catastrophic level without the second accident happening. And if you can prove that it's the second accident that brings the impairments from here, non-catastrophic, to here, catastrophic, then there'd be a catastrophic impairment claim in relation to that second accident. And that can get really complicated when you're talking about whole person impairment or mental or behavioral impairments. You can think of an easy example, I suppose, in relation to, let's say, spinal cord injury, for example. Under the SABs, there's the ASIA scale that determines whether you meet the catastrophic test. And if you're ASIA A, B, or C, you're automatically catastrophically impaired. But if you're D, then you have to meet further tests relating to how far you can walk and whether you've got urinary and bowel impairment. Let's just say somebody is in an accident and they're ASIA D, but they're not at the CAT level. And then there's a second accident and their impairments are exacerbated and they're now at the ASIA C level, or now they're at ASIA D, but they don't, they can't meet the walking requirement. They become catastrophically impaired. It's the second accident that causes that on the but-for test. And it's the same causation test that applies there as we deal with on the tort side. But these causation cases are very often the ones that go to hearing because there can be dispute about what causes what, and it's a tangled web.
Right, but the key point there is that if the second accident tips the scale or is the straw that broke the camel's back, you get catastrophic impairment status. But even though the first accident got you partway there, it doesn't entitle you to claim twice, so to speak, right?
Yeah, it wouldn't be a double CAT
You
case.
can't get double CAT.
Right.
No.
You can. I've had a double CAT case.
Really?
I had someone with a spinal cord injury and they had a head injury.
Worse luck.
Yeah, and I've also had someone with an incomplete quadriplegia in a dirt bike accident and then in a motorcycle accident that he recovered to be able to walk again after being at Lyndhurst. It was on a motorcycle and suffered a complete injury, both catastrophic claims. So there's a double CAT argument in some very, very rare cases. The case involving multiple accidents where one accident makes the other accident worse or the impairments from the other accident worse. That's the more usual case that we deal with.
Yeah. Okay, so there are quite a few questions coming in about some aspects of COVID. I'm not sure we're necessarily the best people to answer some of them, but we'll do our best. One is, what are your thoughts on having clients sign OCF 18 forms or other forms by using available technology like DocuSign? I think that's like a situation where it's a quick call to the adjuster and see if they're okay with it. I think that's a great solution. Any other thoughts on that?
If it's good for the insurer, it's good for me.
Yeah, like it just seems like maybe that's not typical what you would do, but it could be a very easy call that one of the lawyers or the ABS specialists can just quickly call the adjuster and see if they're fine with that. And then there's a lot of questions coming in about personal protective equipment and who has to provide it, and what happens if the plaintiff doesn't want to wear it. I'm not sure if we necessarily are the experts on this type of question, but you guys have any thoughts on these types of things?
Is the question in relation to an in-home kind of assessment or treatment?
So it just says some IE companies are insisting on clients wearing masks. Can you comment on this from our plaintiff side? Are there risks to the therapist of the case, of the case if the client doesn't want to use the personal protective equipment? So I'm assuming what this means is that IE people are insisting upon it, but what if you're treating and you want the plaintiff to wear it, but they refuse to?
Yeah. Well, I'll give you my thoughts on the IE part of it. Nobody is forced to be close to somebody, obviously, in the environment we live in, without protective equipment and masks specifically. So, if you're running a business and you require customers to wear masks, that's your right to do that. If you're a doctor, a healthcare person doing an insurer's examination, you can require somebody to use a mask. I think that's your right to do that. And if the insured person said, I'm not going to do it, and the assessment doesn't happen, then I don't think you can make a bad faith argument against the insurance company there. I think the person would have to wear the mask. And the same holds true for treatment people. You have to protect your own safety. And it can be a challenge. I mean, I had a mediation yesterday where I had a brain injured client who wouldn't do it on Zoom where she was living. She wanted to come into the office. And I had a boardroom set up for her, and we talked about the need to wear a mask unless she's in that boardroom alone with her significant other. But she left the boardroom a few times without a mask, and I had to talk to her, and I know it's a big challenge, and there's no easy answer to it, I don't think.
So, and then this one's sad, and we really hope that a lot of people aren't in this circumstance, but the questions come in, what happens if your client has passed away because of COVID? Can you still settle your case?
Well, that's a lengthy topic. I'm going to sound like I'm selling something here, but I actually wrote an article on death during civil litigation and personal injury litigation in the Ontario Trial Lawyers Association magazine, The Litigator. And, yes, you can still settle a case. The nature of the case is different. So if it's a tort case, for example, when a plaintiff dies, there are claims for future loss of income, future medical and rehabilitation and care needs die with them because they don't need it anymore. So there's a whole body of law around, damages after death versus if someone were to survive. And in terms of the accident benefits context, it's no different. If someone has died, they will not need any future benefits. So there's nothing there to really settle. They would be entitled to certain death benefits and funeral benefits if the accident could be connected, if the death could be connected to the accident and happened within the requisite number of days. So anyway, this is if you have a real interest in the legal aspects of it, I encourage you to find that article that I wrote on The Litigator. You can email me and I'll send it to you.
Yeah.
Yeah, if you pass away because of causes unrelated to the injury, to the accident, then your SAVS claim goes away, and there's no more benefits. The tort claim changes drastically. You're entitled to the past losses, but the future losses are no more. The situation, I suppose, would be different if you could prove that the death related to the injury. And there might be cases where someone passes away from COVID-19 where that's the case, where they're compromised because of an injury, and it'd be a big fight. But there'd be a case potentially where you could prove that someone passed away and wouldn't have passed away but for the pre-existing injuries that relate to the claim. You could see that happening.
Battle of the experts on that one.
Yeah.
So, so I'm just going to check and see if there's any other questions here for us. Oh, here's a good one. What's the most up-to-date argument regarding the cost of CAT assessments being outside the medical and rehabilitation limits?
I don't think we need an argument, do we? Isn't it settled
Yeah.
and established?
Yeah.
Yeah, so it's quite clear, I think.
Okay. Okay. So those are all the questions we really have time for now. So I just really want to thank everyone for attending today and submitting your questions to us before as well as during the session. We really appreciate it. Like I said, if we didn't get to your questions, because there were a couple that just came in right at the end, we will try to respond to them, and the answers will be on the PIA website. And this will also be recorded and will also be posted to the PIA website, I believe. So we wish you guys all the best during these really challenging times. And thank you so much for all your service that you're providing to a lot of our clients. We know it's really greatly appreciated. So thank you.